last time?
Boxer one. Where? Oh, great. do it real quick. Oh, I see. Yeah, you got it. didn't want the signature alone on the page. I was like, you talking about the very last? Oh, well, yeah, I couldn't fit it all on that. You know what I mean? I did.
Okay.
What year is this one?
It's 20. Well, yesterday you said you were on. Stop. I'll check it. Yeah.
So that's if you go to lunch, come back at 1.
Okay, because that's what I'm waiting for.
Yeah, go ahead.
Okay.
I think that's changed. I think that's a little changed since then. Tom, did you do anything with the standing for submitting case? Did you rearrange anything?
Yeah, I made it all up. But don't look at the couple of
Alright, it's just
the
a little
most recent
okay.
version of everything off the website. I wouldn't use the book.
Yeah. This is correct. This is the most up-to-date one off the website. Good.
Is it adding something or is it deleting something?
No, there's something, it's one of the times that the judge says that the computer must be unanimous. Just,
That's not in there?
one of the times, it's not a problem. Is that the last thing? Who's in the last?
Instruction.
So the indication Jerry's the one who's talking about.
All right.
Oh, no, I'm sorry.
Yeah. Well, yeah.
Drive me bonkers. I just couldn't believe that they said that from us for the whole we could just people were doing something. We don't go that high. I have been the highest nonsense in the world.
Okay.
Ready to go on the record?
Yes, sir.
Back on the record, we were selling council president.
We just sent an updated version of the packet again. I don't know,
Very responsible, right?
we just sent it to Clark and to Ms. Aldoni and Mr. Glenn. So there were some changes Mr. Glenn brought up that we could agree to and others that we can't, so we'll have to discuss.
Can you also print us a copy, Madam Clerk? Pardon me? Can you also print us a copy?
You don't have a copy. Oh, boy.
Okay, of course, prior to giving closing argument, I'll read the closing argument instruction. I will now state the things that need to state. After y'all are finished, once we get to that point, I'll read the introduction and final instructions. State any objection that you read.
No, sir.
Okay. Then I'll read the statement of the charge. State any objection that you read.
No, sir.
State any objection. Just go page by page. I'll state any introduction to homicide and justifiable homicide instruction.
No, sir.
Defense.
None. No, sir.
State any objection to excusable homicide instruction.
No, sir.
Defense.
No, sir.
First degree premeditated.
No, sir.
Yes.
Yes, sir, I do. If you take a look at the first page of first degree premeditated and go down to the paragraph at the bottom, it's the intent with which an act is done. That paragraph, if not, I don't believe that's part of the standard instruction. Don't look at it.
Right. It is a standard instruction. It's taken from the burglary instruction. It is a true and accurate statement of the law, and I would ask the court. I inserted that there because I intend to argue it to the jury. So it's an accurate statement of the law.
Lynn, any other argument or comment?
Well, I understand Mr. Packard's point, and I can tell you that it's not part of the standard first degree instruction. So I don't think it's proper to insert it.
state's request that this language be included in the first degree premeditated murder instruction. It reads, quote, "The intent with which an act is done is an operation of mind and therefore is not always capable of direct positive proof. It may be established by circumstantial evidence like any practice case, unquote. The defense objects to this language being included because it's not a standard instruction." So you can see, and I agree, it's not a standard instruction under the first degree premeditated murder. It is a correct statement of law that's included in burglary instruction, and maybe other areas too, certain burglary instruction. I will elect over defense objection to give it as it is a correct statement of law. I think it's appropriate to give it in this case to request under the facts that have been presented in this case. I'll look when I get a chance to make sure that there's no prohibition against giving this, but absent any authority that prohibits me from giving it, I'll agree to give it over to defense objection. I reserve the right to change my mind, of course. The defense doesn't have any other objections to that instruction other than the intent language.
Well,
I'm asking.
yes or no? Looking at page P3 to legal law enforcement officer instruction, it looks like it misplaced. It's in the middle of the mode of instruction. Because the next page after fleeing to eluding is the remainder of the mode of instruction. Do you disagree with me on that?
I don't agree that it's misplaced. I purposely put it there. I think I referenced this yesterday before we stopped. The state indicted the defendant for first-degree murder of a law enforcement officer. Also, I would note for the record, the standard instruction normally reads, if you find the defendant guilty of first-degree murder, you must then determine, that whether the state has further proven beyond a reasonable doubt that Gary Morales was a law enforcement officer engaged in the lawful performance of a legal duty. I added also an additional element or burden to the state, and that Eriese Tisdale knew Gary Morales was a law enforcement officer. So just so we're clear, I added that as well. That's not the standard, but I think it's an accurate statement of the law. Quite frankly, I think the standard instruction is wrong, and eventually that will be addressed. But I added the fleeing there, Judge, because one of the things I debated requesting of you was to instruct the jury of certain lawful activities for law enforcement. For instance, conducting a traffic stop, making an arrest, pursuing and fleeing and eluding. And back in the day, the resisting and battery legal instructions had that provision in it. And as I looked at them this morning, they no longer do. So here's the thought process. The defenses are obviously trying to suggest something nefarious, illegal, and improper by Sergeant Morales. I also have an affirmative obligation to prove that he is engaged in the lawful performance of a legal duty. I had you put fleeing and elude there so that that's a definition of a legal definition of a crime, and to the extent he was pursuing under that statute, he's engaged in the lawful execution of a duty. So I think it makes absolute sense to put it there. This is not a charged crime. You're not telling him it's charged. You're just simply reading that instruction, and then I'm going to argue to them that's a legal duty. That would be one is making a traffic stop as a legal duty. I didn't have that, I didn't put in there with that, but certainly pursuing somebody for fleeing and eluding is a legal duty. And I might point out that this becomes even more important in light of the fact that the defense has now offered or intends to offer provisions from the policies and procedure manual, because this is going to enable me to explain the difference between a policy, which has no legal effect or impact in this case, or force in this case, and a law which is applicable. So that's why I put it there.
Judge, if I could give a little bit further on argument. I understand a lot of it, but I disagree with it for a couple of reasons. One, the state can make the argument that they want to make. The problem I have is that this fleeing to eluding is not even a crime charge. The crime charge is fleeing to elude like the time and we find out at the end of the jury question. For multiple reasons, I think it's confusing because fleeing to eluding is a left of fleeing to elude is like to down, so then we would have fleeing to elude twice in the body of the element and then in the left included section. It's just way too confusing to do at a time that's step.
Say that you have a comment.
I guess my only other comment would be if the defense wants to stipulate to an instruction that a lawful duty performed by a law enforcement officer would include such things as making a traffic stop, making an arrest for a crime, something of that nature to identify what is a legal duty.
Well, my question is, none of that's alleged in the indictment.
Sure, it is. So none of what?
Fleeing or eluding, making a traffic stop. The indictment alleges was engaged in lawful performance of his legal duties as deputy sheriff.
Right, which means everything. So again, I would say it could be a traffic stop. I don't. They entered a plea of not guilty to that indictment. The indictment is sufficiently pled, and I do not have to. Just like in a Bat Leo case, we do not, and there's plenty of case law that we do not have to specifically identify the legal duty the officer is performing.
But you could.
Well, I could, but again, I don't have to. So I don't. This is not an inaccurate or incomplete statement of the law. It's just that it's the definition of a crime. And it's going to be instructed again later that exact same crime is a lesser included.
Right, under count 4.
Right.
State have any objection to second pre-murder?
No, sir.
Judge, before we go, I think we could look at the last page of first degree murder. The section does the court now prosecute everything the county sheriff deputy and officer within the meaning of the law. I'm objecting because it's not part of the first degree murder instruction. It's a code from a different crime.
I'm sorry, where are you referring to?
At the end of the first degree murder instruction, which is right after the...
Oh, I see.
Okay, and just,
Okay, Mr. Barry.
right, so that actually, originally I pulled that language from either the resisting with or the bat Leo section.
In resisting without is in there too.
Huh?
I think it's in the resisting
Yeah,
without.
I think you're probably right. And then as I did the lessers, if you take a look, I don't know if anybody has access, but for whatever reason, again, my point here is the instructions are incomplete. But if you go to manslaughter, 7.7, and I'm pulling it up now.
I get it to back it off point. It's part of the manslaughter instruction. I see
Yeah.
that.
Right.
My objection is it's not part of the first remote instruction.
So, I mean, it's an accurate instruction of the law. You're going to tell them that multiple times. You know, you're going to tell them that in the aggravated assault on a Leo instruction. I think that's part of the standard with that. So, again, the instruction.
The one I have says, if you find the defendant guilty of first-degree murder, you must then determine whether the state has further proven beyond a reasonable doubt that Gary Morales was a law enforcement officer engaged in lawful performance of a legal duty, and that Eriese Tisdale knew that Gary Morales was a law enforcement officer.
What charge is that you're looking at?
That's the last paragraph.
Judge, I think Mr. Glenn's talking about the next page. That begins with definition of willfully at the top.
Right. The next page is actually part of the first remote instruction.
Oh, okay. I see this. Okay. I misunderstood. Well, isn't that a correct statement of the law? And it's an instruction given
Judge,
later in the instructions.
let me tell you this way. Of course, a deputy is an officer within the meaning of the law. My concern is that, honestly, I don't want to create risks with the case against the vote because it's really improperly instructed. So I prefer we stick to the standard instructions for they enough to clearly inadequate. And this instruction that the state's putting in there is not fixing inadequacy. They don't want to have it.
I'll note the defense objection. I'll include it. I think it's an appropriate statement of the law. I think it would be applicable under the facts of this particular case. Further, the indictment count one alleges that Gary Morales was a law enforcement officer with the San Diego Sheriff's Office. So I think it's necessary in the facts of this case to include that. So I'll include that language as it will be included, if I'm not mistaken, later on in the other instructions. All right. Okay. Depends on the other objection to the first-degree premeditated instruction.
None of them were I mentioned no such.
Depends on the objection to the second-degree murder instruction.
Yes, the same objection to the last paragraph of second-degree murder is applied. It's the same statement the court now in first degree, second the county sheriff deputy is an officer in the meaning of the law. I feel that I need to raise that objection.
State, you get a comment on that?
No, it's same position.
And I think under the facts unique to this case, it's necessary to give that instruction. It's an appropriate statement of the law. It's included in the portions of the instruction. So I'll give it over to defense objection. So we have objection to the manslaughter instruction.
No, sir.
Judge, if you take a look at the manslaughter question, I do have an objection. I'm looking at the standard question online right now. My objection is at the bottom of the manslaughter question, two paragraphs. One that at the time of the manslaughter, Gary Morales was a law enforcement officer, and then the following paragraph, which is the same one we just discussed. look at on the last page of manslaughter, you see pleadable homicide at the top. If you go down to the last two paragraphs.
Oh, okay, I'm sorry, I see what you're saying. I was looking at the first page, okay, I see what you're talking about. State any other comment on that?
I tried to keep the language consistent between the charges. If you want, I can go back and insert. It says, it would read, Gary Morales was at the time an officer who was at the time performing duties that were within the course of his employment. Again, that doesn't have any requirement that duties be legal or lawful, so it actually lessens my burden. Furthermore, it does not have language that requires the defendant knew Gary Morales was a law enforcement officer, again, lessening my burden. So, again, I don't think that that particular instruction is completely accurate. I think the instruction as I wrote it more accurately depicts the law and in fact increases my burden. So, but I would also note that there is the language we've been talking about, the non-obstruct you act. The victim is an officer, so I don't think that that's a very accurate statement of the law. So I thought for consistency's sake, I'd use the same language that I use for first degree murder, second degree murder. It'll be an aggravated assault on a Leo and so forth.
All right. Mr. Glenn, you're objecting to the next to last paragraph where it says, at the time of the manslaughter, Gary Morales was a law enforcement officer engaged in lawful forms of legal duty, but Eriese Tisdale knew Gary Morales was a law enforcement officer.
That's correct. As well as the following paragraph, which we just discussed.
And your objection is that it's not standard language under that?
That's correct. I'm looking at the recent version of the standard instruction.
I believe that it's not standard. I just want to make sure that's true. I'm just looking at it. Well, does it, does it not increase the potential punishment if the jury finds Mr. Morales was a law enforcement officer?
Yeah, sure. I mean, that's if you find, you must determine whether we prove that, and that would be, I assume, would make it probably an F1, maybe. I don't know, and I didn't bring my statute book with me. But
I think that's the case. I'll go ahead and give it over defense objection. I recognize it's not standard language under the manslaughter instruction, but again, under the unique facts of this case, I think it's appropriate to give it if requested by the state. In all candor, also the other instruction I'll give, also for the reason I've stated, it's an accurate statement of the law under the unique circumstances of facts, which in this case I think it's appropriate to give it. So I'll give it also for defense objection. State objection to aggravated assault on a law enforcement officer.
no, sir.
Defense.
So I just wanted to make sure I understood you correctly. My manslaughter instruction of justice was overruled.
Yes, sir. I'll note the defense objection. We'll overrule it. We did that over defense objection. I recognize it's not standard, but it would be appropriate if the facts presented in this case.
Now, moving on to aggravated assault on a law enforcement officer, which is completely identical to the standard, so I don't have no objection.
State, I assume doesn't have any objection.
No, sir.
Moving on to possession of firearm by convicted felon. State have any objection to that instruction?
No, sir.
Defense.
No objection, completely identical to the standard.
State have objection to fleeing to elude a law enforcement officer with license, siren activated.
No, sir.
Defense.
No objection, completely identical to the standard.
All right, now, instruction, state have objection to that being read.
No, sir.
Defense.
Judge, if you look at the top, it says the left included crime indicating the definition of first degree murder or second degree murder language for the lesser included for the other crimes as well. Aggravated assault and
Yeah, it's on the next page, sir.
legally is not. Wait a minute, I don't even state that. They put it above each letter. Never mind, I think it's good.
I'm trying to think.
Then I withdraw that question.
Those are all, looking at 99.9% sure those are all the category 1 lesser offenses. Right? Those are,
He asked for all category 2 lessers, and that's what I
Category
did.
one.
Or category 1.
that's all category 1 lessers.
From the book. I just want to make sure that they agree with that. That's what my book said. I don't know anything about lessers, to be honest with you.
I just all the category 1 letters.
Now, is the state of defense requesting the other lessers other than those that are provided, such as category 2 lessers?
The state is not.
No.
Now, state had an objection to possession of firearm discharge causing death instruction.
No.
Defense.
Josh, I apologize. I thought you were going to go through the letters and after they were in your adjustments to the language and say.
I think it was misunderstood. Do you have any objection to lessers?
I do need to direct attention to the assault on a law enforcement officer. I do have an objection to the very last paragraph, same with my other objections with my part of the standard.
Which one's that? I beg your pardon.
Under assault on law enforcement,
Yeah.
that's where it says the court now instructs you to sentence the county sheriff deputy as a law enforcement officer.
That is part of the standard for, that's part of the standard instruction.
Like, let me double check it.
Okay. Yeah, it's in the standard there, Mr. Klein.
Yes, sir. I apologize. I was looking for that objection.
The objection to the language and improper exhibition of a firearm.
No objection to that.
Objection to the lesser, referred to as simple assault. You object to assault? No? Mr. Clinton, no objection to assault?
No objection.
And finally, fleeing to elude the law enforcement officer, lesser offense, state any objections to that?
No, sir.
Defense?
No.
Mr. Mooney, objection to possession of firearm and possession of a firearm and discharge of firearm causing death instruction.
Judge, I just want to note for the record that it deviates from the standard I discussed it with Mr. Eisenhower, what they basically did, I'm not objecting, I want to be clear on the record that I'm noting the differences. The state basically combined the standard and question to make it 1 or 2 sentences rather than having several different paragraphs. So that's why I'm not raising an objection because I think it needs to stay away. I just want to make sure it's
I understand. Other than that issue, you don't have any objection to the language?
no.
As we discussed yesterday, we'll read pleading not guilty, reason without further proof instruction. State any objection to that, be right?
No objection.
Defense?
No.
I'll read weighing the evidence, the first 2 paragraphs, one's designated 1 through 7, I think we agreed there was. was at least one witness who's been convicted of a felony, and it's necessary. State any objection to this proposed instruction?
No, sir.
Defense.
The defense has no objection to where the entire weighing the evidence is with.
On the next page, discusses expert witness. There was at least one expert witness tendered, so I think those paragraphs are
Because I do, I have no objection to the expert witness paragraph. I'll take the board of account.
State any objection.
No.
Now, the defendant not testifying instruction, I have to give either paragraph or both, or neither one, depending on the defense requests.
If I could have the court back up, there was a couple of things I noticed on the page.
Okay.
I was looking at the during portion of the book, there were two questions that I just did not put in. One question is the law enforcement witnesses, I think should be applied, and the other one basically talked about the state, whether or not the state is right, voting has nothing to do with how many witnesses they called, how many witnesses were placed in the evidence, it has to do with the quality of the evidence. That's not there, and I think it should be a part of the way.
It's in
It's under 7.
it's on the first page of weighing the evidence on the paragraphs.
Okay.
Next,
That is one
this is the defense request, either paragraph or both, or neither paragraph of the defendant not testifying instruction.
yes,
You wish to have both read?
yes.
Now, defendant statements instructions included. There was one alleged statement, as I recall, about one of the officers testified. The defendant is alleged to have said, "Don't kill me, or don't shoot me." Usually I get these in Miranda situations. The state requesting this instruction be read.
No, I'm not.
Defense.
I requested
I'll read rules for deliberation in its entirety. State any objection to that being read.
No, sir. Oh, no, sir. The defense did raise an issue with respect to paragraph 5, so we should probably talk about that. There is a note in the instructions with respect to it's somewhat ambiguous in my mind. Let me pull it up, unless somebody has an open book in front of them.
What the instruction does with respect to sentence of paragraph 5 specifically, it is the judge's job to determine the proper sentence if the defendant found guilty should be omitted whenever the jury is going to consider penalty. I suggested to the state that we need to take that out.
So here's what it says, and this is where I say it's ambiguous. It says, when the jury is to be involved in a penalty phase. Well, obviously, as Ms. Saldoni has put it so well, we're that kind of putting the cart before the horse, you know what I mean? Because this is the first guilt phase. I think it's a completely appropriate statement of the law that at this phase they should not be considering punishment. So I'm amenable to changing the language there to make it more, I guess, conducive with what we're doing here, but I think there needs to be an instruction that this particular portion of the case should be decided without.
Well, why not just leave it, as Mr. Glenn suggests, your duty is to determine if the defendant's been proven guilty or not in accord with the law. And just leave it there. Now, I know when I read the preliminary instructions, I omitted that second sentence because it would be, in my view, confusing to the jury for them to be instructed the judge's job to determine the proper sentence if the defendant is found guilty because of the advisory portion of the trial.
Well, of course, that is an accurate statement of the law because it is your job. But also, as Mr. Eisenhower pointed out, there are other charges here, not just the first-degree murder case, that, theoretically this could apply to. I agree that it's your duty to determine whether or not the defendant has been found guilty or not in accord with the law. Why can't we just say at this stage of the proceedings you should not concern yourself with any potential punishment or something along those lines?
Okay with these? Defense have any objection to that? Now, listen, with all respect to the drafters and the rules and the Supreme Court, I don't write this stuff.
Right.
humbly suggest might do a little better job maybe, but no, I haven't volunteered to be on the committee and all that stuff.
George, I haven't done, well, because the question clearly that it to be moved, I have to judge.
What was your suggestion, Mr. Bagwell? You're right, the other counts, other than count one, it is the judge's job to determine the proper sentence of the count.
Right, I mean, I was just something to the effect of, you should not concern yourselves with potential punishment at this stage of the proceedings.
As to count one, as to counts 2, 3, and 4, it's the judge's job to determine the proper sentence of the defendant's family.
Yeah, that makes sense.
It's having other objections to that language.
No other objection than to remove that second line.
I'll request that language. I think it fairly informs the jury as to count one, what their role is. I think they probably have an idea. It also advises them as to the other remaining counts, it's the judge's job to determine the proper sentence without jury.
Well, how do we want that to read?
Exactly what you said as far as count one, but
Okay, so what I put here was, it is the judge's job to determine proper sentence if the defendant is found guilty in counts 2, 3, or 4. And you should not concern yourselves. Not consider potential punishment.
that's to count one at this stage of the proceedings.
Okay, so read, its job, your duty, etc. It is the judge's job to determine the proper sentence if the defendant is found guilty in counts 2, 3, or 4. You should not consider the potential punishment as to count one at this stage. Or how about if we say, nor should you consider?
That's fine.
Okay, that reads that. Okay. Nor should you consider the potential punishment as to count one at this stage of the proceedings.
Depends on the other objection other than that already made on that language, paragraph 5.
I would object to the additional.
I'll move the defense objection. I think it's a fair explanation of the jury's role with regard to sentence under the circumstances of this case, of course. I'll read cautionary instructions. State have objection. That be read.
No, sir.
Single defendant, multiple counts, as there is, of course, one more count alleged indictment. State have objection to that instruction be read.
No, sir.
No. Verdict instruction. I don't remember the number of it. It's 3.12 is my vote.
Right. All right, yeah, let me put that in there.
And because, suggested, because they're fully lesser provides the jury, I'll read all 3 paragraphs.
Where does that go, Judge? Does that go after single defendant, multiple count?
It comes before that,
Does it come before cautionary instruction?
it comes after that. So I don't like this.
All right.
Just tell you what it says.
Yeah. Okay, so I inserted it directly underneath cautionary instruction. I have removed all the, I guess, kind of suggested verdict form. You now have a verdict form. So it will read you may find the defendant guilty as charged in the indictment or guilty of such lesser crime, including as the evidence may justify or not guilty. The return verdict of guilty should be for the highest offense which has been proved beyond reasonable doubt. If you find that no offense has been proven, and of course the verdict must be not guilty, and then only one verdict will be returned as to each crime charged. The verdict must be unanimous. And then it says they are as follows. So then you'll have an opportunity to.
Once I finish reading it, I'll explain.
Okay, so I'll send, once we get done, I'll send this out version 4.
Is there any objection to 3.12, the third instruction?
Well, he's looking at that, Judge. So in submitting the case to the jury, some relatively new, at least from a person who never tried any cases, relatively new additions to that instruction.
You referred to yourself?
Me. Yes. It says many of you have cell phones. Now that says if you let them keep them during the trial. I don't know what's been going on in that regard, so I don't know if that instruction needs to be there or not.
Well, what I've been doing in trials here is reading that instruction in its entirety. I have him give their cell phones to the court officer to keep in his or her custody until they're finished and they're returned.
Okay.
When they return to the verdict, or until they're all in addition.
That's fine. So I just put it all in there. What I wrote. Oh.
I've looked at what back at all of
The objection is to the case of the juries. State have objections to the form of verdict.
No, sir.
It's the objection is to the form of verdict.
form of verdict in
The verdict.
yes, no.
Now, well, a little bit. How much, when you get to closing argument, how much time do you all request?
I think I would, I'm going to ask for an hour and a half. I don't really anticipate needing it, but just in the event, I don't want to bump up against the wall. But I bet think that's more than enough for me.
Definitely won't be longer than that.
Or that upon agreement, both sides will be afforded 1.5 hours. If they get close to running over and you need a few more minutes, I'll be happy to award it to you, I'm sure. Now, do y'all want to do this afternoon or tomorrow morning?
I prefer to do it tomorrow. I mean, I came in early. I've been working since 5 on just the jury instructions, and we're not done with these last issues we have, so I'd like a little time to prepare.
I'll let the court decide. It doesn't matter to me either way.
in to let y'all start closing argument tomorrow morning at 8:45. If y'all please promise to be here promptly and get ready to go. And the jury's here. I know everybody probably has a lunch break. What I'll do is, when they're all here, we'll bring the jury in. I'll apologize for the delay. We'll do the defense portion of their case. That is, read the stipulated instruction. I'll read the agreed upon portions of the defense exhibits 2 and 3. The defense can announce they rest. I'll ask the state if y'all wish to present any rebuttal. If you answer no, if you say no, I'll tell the jury they close the evidentiary portion of the trial. We'll have to return tomorrow at 45. State have an objection to that.
No, just the, well, no objection to that. No, something else I want to ask before we bring that. I just wanted to get a look at what you highlighted and make sure it matches what we all think. You highlighted since you were highlighting what we were doing. I want to make sure we're all on the same page so there's no mistakes. Thanks, Judge.
The defense has an objection to that procedure, so we look at the highlighted portion. Any objection to that? So you bring the jury in and I'll finish with stipulated instruction, read on portions of those documents, publish the
If it's okay, I'll publish this first, then have you read that, and then
The only question I had about this, Judge, and I don't know what the defense's preference was. I noticed highlighted what I think is the appropriate portion, but there are some headings here. Like it says radio communications, and there's a colon, and it says prior to initiating vehicle stop. You just highlighted it prior to initiating vehicle stop. I think that's appropriate. I just didn't know.
That's all, whatever you highlighted, I'll agree.
I understand. And then the reason that's commonality is in the fourth paragraph, you have position of the vehicle highlighted in the colon, and the explanation. Consistency's sake, I guess, one way or the other, but it's something I'm sure it's yours. You see what I'm saying, yes.
So we're asking about the headings we had down.
So, radio communications, initiating stop. The whole heading here.
What's that?
Here, let me-
But you already have one instruction.
Yeah. Oh,